So just breaking down there, just some of the issues we're seeing unfold. Talk to us briefly from where you sit, the situation and how you describe the state of the Supreme Court.
Thank you very much. Sophie, I must appreciate that you've actually broken it down very, very well. What we see here is that 3 judges are going to leave by operation of law. That's on account of age.
Right.
The Chief Justice, the Deputy Chief Justice, and Justice Tunoi. And then 3 others have misconducted themselves, so ought to leave immediately because a tribunal needs to be formed. And then that one leaves only Justice Mokin Wanjala.
Yes.
So we can say 6 need to go. It's almost like reconstituting the...
So on our Saturday poll question where we're asking whether our viewers think the Supreme Court should fully be reconstituted, you agree with that? I
agree with that totally, because the 6, the way it is, the state now, they don't inspire confidence.
At all?
At all.
So there were attempts following, this ruling by the Court of Appeal, and then we saw the move by Judge Njoki Ndongo, and then the CJ moving it closer. Does it surprise you? Because largely people would imagine when you have a matter before court, you want it to be expedited. You want it to be finished as soon as possible, but to see Rawal challenging the same, what does this say to you?
That's the irony of it, because the Chief Justice, what the Chief Justice did was purely administrative. They had approached the Supreme Court under certificate of urgency. It was urgent. The Chief Justice just made it even more urgent for them. And yet they are complaining. And then the irony again, there is an application which the Supreme Court will have to deal with come Monday, which has again brought the same judge has brought a preliminary objection on what the Chief Justice has done, further to delay it. So what we are going to see is that the lawyers for both Tunoi and Rawal will be further putting a lot of roadblocks so that they delay. And as you said, the litigation on Tunoi has been there for 2 years. And they'll want to delay it further and further. He's now 72. They have put us in a very precarious situation whereby even if the court arrives at a decision that it is 70 years, what will happen to these other cases that they sat on when they were not judges?
Isn't there the merit in the argument by Rawal's counsel that having a decision having been made by Judge Njoki Ndongo to have the matters heard on the 26th of June, for the Chief Justice to then, you call it administrative revise or overturn the same, that's an illegality because there should be a 5-judge bench sit to do the same?
No, the Chief Justice never overturned the injunction that was issued, or the conservatory orders that were issued by Justice Njoki. What the Chief Justice did was to move the date even earlier than the way they wanted. They had gone there under certificate of urgency. When it's urgent, then let's do it urgently.
Yes. So because largely it appears many know at this particular point most of where these judges, they stand on this critical issue, especially on the age requirement. What then happens? Because the law requires that 5 judges sit on this matter, and we've just broken down how several of them are eliminated from that particular bench. So then what becomes the situation if at all we go to hearing?
I want to see, I would not want to go into the merits of it, because I think these are some of the things that the lawyers will be, the applications that the lawyers will be raising and will have to be disposed of. And one of the reasons is that they are conflicted in one way or the other. And of course, the court can also argue that on the doctrine of necessity, which they have invited before, they can still listen to it and dispose of it. But we should not lose fact of the statement that was issued by JSC yesterday, that already there are 12 judges who have had this case, and all of them are unanimous that it's 70 years. That is 5 at the High Court, and then 7 at the Court of Appeal. We want to see if 5 at the Supreme Court will overturn it.
And what happened, do you think, to the failure in the mediation talks last week, Thursday, between the Law Society of Kenya and the Judicial Service Commission? Why is it difficult to find a middle ground to have a conversation out of court? Because in court, it is complicated.
There is nothing to mediate. In fact, I think it was ill-advised for LSK to have even gone that route. I remember when I was the Chief Executive of the Law Society, and the then Council, when the litigation started, decided, and which was the correct decision, not to be involved in this case, in order to allow LSK then to stand with the public interest by offering to mediate a constitutional issue. When it's constitutional, then they must concede. There is nothing of mediating. Yes.
Because the law speaks for itself.
Yes, it's constitutional.
And there are those who've argued in such a delicate issue and where conflict of interest is really glaring, that bringing in Commonwealth scholars would be the way for Kenya to go at this particular point to inspire confidence, because then there will be many questioning if at all the Supreme Court judges, as currently, you know, the court is currently constituted, sits to hear a matter in which many of them have already pronounced themselves, then issues would arise. Do you agree with that kind of a proposal?
I don't agree with that.
Yeah.
This thing is as clear as day and night. It is 70, and the High Court has said so. 5 judges at the High Court have said so. 7 judges of the Court of Appeal have said so. It is black and white in the Constitution that it is 70. In the advertisement, when Justice, the former Lady Justice, the former Deputy Chief Justice left, the advertisement indicated clearly that this position, the retirement age is 70 years.
But they have an argument as well. Those that are arguing they were employed when their, what if you refer to it, contract read 74. So the rules have changed. Why should they apply to them in specific? Yeah,
that's a very good argument, but that argument has been overthrown. Indeed, look at the 7th bench of the Court of Appeal. It was a mixture of those who were employed before the Constitution 2010 and those who were employed after. And they still agreed on that, because they put the interest of the country first, and also to their true calling, and also the oath that they took that they will defend the Constitution. But what we are seeing with the judges who are litigating is that they swore to defend the Constitution, which now they want to abuse.
All right, before we let you go finally, do you think as Kenyans we made a mistake to put in place a Supreme Court and going by the issues we are seeing?
No. Supreme Court is required. It is the personnel that are misconducting themselves.
So it's the people, not the institution.
Yes.
All right, thank you so much. Apollo Mboya, who's a commissioner with the Kenya Law Reforms Commission, as well as advocate of the High Court, sharing his thoughts on the crisis at the Supreme Court. Of course, the story will continue to follow for you and bring you all the details as they continue to unfold in the coming week.